Well, today we have another student of the Marc Stevens School of Pseudo-law and Legal Bullshit. And he's getting ready to go to court, and we have 2 hearings here. So let's begin.
Your Honor, appearing specially, and at this time I move that this case be dismissed for a failure to state a case.
All right. We'll have a set for oral argument on this Friday.
Objection. The prosecution hasn't submitted any evidence of jurisdiction to continue this even a minute longer. I move that this matter be dismissed right now for failure to state a case.
Okay, and that motion is denied.
On what grounds?
Your Honor, Mr. did file some motions, and I believe we were going to be addressing them today. Obviously, because Judge Payton isn't here, that is why we are resetting it for that time. So,
And again, Mr. What time on Friday for oral arguments for you to present? Whatever motions you have at that time?
I've presented my motions. The prosecution has had more than 10 days to respond, and as I mentioned, there's no evidence of jurisdiction to continue this.
Okay.
and Your Honor, I'm sorry.
Go ahead.
At the last court date, Judge Payton did give me leave to orally respond
Oh,
to
okay.
the motions as opposed to filing written responses.
Okay.
And that was to be today, so if she has a response, then I'm here to hear those.
But it's not going to be today. I'm resetting it before Judge Payton.
On what grounds?
8th, so that you can present your oral arguments before the judge.
I have no oral arguments. All of mine are written and they've been submitted, and the court has no jurisdiction at this point to continue this.
Again, if you'll take a copy of the order, April the 8th at 11 a.m. Thank you.
And now he has a chance to give oral argument for his motions. Let's listen.
There are no notes in there, Your Honor.
Sorry?
I didn't write any notes for you.
That's perfectly all right. Tell me where we stand.
So, Mr. It looks like he was originally in front of Judge Bacall behavioral, and then it was transferred to us. It appears that he filed some motions. I'm just looking at these now. Mr. says that he is challenging the jurisdiction of the court.
Okay, let's talk about that. Okay?
Well,
Tell me what's on your mind.
I've filed some motions, sir.
Tell me about it. Tell me why you think the court doesn't have jurisdiction over you.
The argument is in my motions,
All
sir.
right, but tell me outright. Just explain it to me. Okay?
Is there something you'd
I haven't
like?
had a chance to read your motion.
Is the
I got
prosecution?
your file for the very first time. So talk to me, please.
Well, at this
Tell
time,
me why this court has no jurisdiction.
if the motions are unopposed, I'd ask that they be
Sir,
granted.
no. See, that's not the way it works. Okay?
No?
It's not the way it works. Give me a sense of your motion. Why don't I have jurisdiction over you?
Sir, is there something you'd like clarification on? Because my
sorry?
argument is in the motion.
Mr. Listen, I know you've been here for the greatest part of the morning. I'm sure you recognize that I'm a patient man. Okay? And I'm pretty easygoing too. Okay? But I've been a judge for a very long time. And I've been a lawyer in the criminal justice system for 40 years. I know what I'm talking about, okay? And I'm perfectly willing to hear your motion. Right? If you don't want to tell me, that's fine. What I'm going to do is reset your case, and I'll read your motion. And if I think I need to set a hearing on it, I will. If I think I don't need to set a hearing on it, I'll just rule on your motion. I'm giving you a chance, son, to tell me what's on your mind in terms of why you don't think this court has jurisdiction over you on a traffic ticket.
Oh, sir, that was her claim. I never made such a claim.
Okay. All right, here's what we're going to do, sir. I'm going to read your motion. Your case is back from Judge McCall to me. I'm the judge assigned to your case. I'm going to review your motion, and I'll, if I think I need a hearing on the motion, oral argument, I'm giving you a chance to argue it right now, but you're declining to do that, which is fine. That's your right. You don't have to argue it. I'll just read your motion, or motions. If I think I need a hearing, I'll set one. If I don't think I need a hearing, I'll rule on your motions.
Could I get something clarified, please?
Sure.
At the last hearing, the judge said 10 days for the prosecution to review the motions, and it's been more than 2 weeks, I believe.
Actually, that's not here.
Uh-huh.
I don't see that. Judge McCall, my colleague, made note that it was transferred to me. I was the judge originally assigned. There are 8 judges on the bench, and judges get assigned cases in a 1 through 8 repeating rotation. So your case was assigned to me in the ordinary rotational course. You got moved over to Judge McCall, thinking you might be eligible for Judge McCall's behavioral health court. But apparently that you don't think that's a good fit, you declined that, and now you want to go forward on the motions, on the merits of your motions, which is your perfect right. But I'd be telling you something that wasn't true if I told you I'd read your motions. I haven't. I'm looking at your file for the very first time, son.
Is
Okay?
it objection? Point of clarification?
I can't hear you.
Point of clarification? Is it required that you read them, or I mean the prosecution has had time to read
I
them?
have to read them. I'm the judge. I have to read your motions. Can't rule on your motions if I don't read them.
But
I'm not going to grant the motions because the state has not filed a written response. I'm not going to do that. That's within my discretion not to do that.
is the
There's
prosecution?
no rule that says I must. There's a rule that says I may, but there's not a rule that says I must.
And is
I'm
that
not here to argue with you.
Yeah, me neither, sir.
Okay.
I'm just seeking clarification on the
Trying the
nature
best I can to clarify for you.
on the nature and
Give
cause of
you
these
an opportunity
proceedings.
to argue your motion if you want. If you don't want, that's okay, no problem. Still going to read your motion. If after I read your motions, I want a hearing, I'll set a hearing, which is my right. Right? If after I read your motions, I don't want a hearing, I'll just rule on your motions and give you a date to come back to court to hear my ruling, one way or the other.
Point of clarification, in the previous hearing, Judge McCall stated that I was innocent of jurisdiction, which is an interesting way to put it. But
Judge McCall, there's nothing here, son, to indicate that Judge McCall said that there's no jurisdiction. Jurisdiction here, let me see, let me help you if I may. Okay? I'll help.
objection. Point of clarification.
No, please, Mr. Listen for just a quick second,
All right.
okay? Please. Okay? Jurisdiction in a criminal case is acquired over a person when that person is served with a charging document. The criminal process is the same whether you're talking about a barking dog or a homicide. There has to be a criminal complaint. That's what gives the court jurisdiction. Criminal complaints issue through the executive branch of the government, cops, prosecutors. Okay? I'm not the executive. I'm just a judge. I call balls and strikes. Okay? I'm the third branch of the government. But jurisdiction is acquired, in this instance, when that Arizona DPS cop wrote you this traffic ticket and you signed for it. That's where jurisdiction attaches, sir.
Objection. Point of clarification.
No, please. I want you to stop saying that.
Well, I need some things
Okay?
clarified.
We're not here to hear objections. If you need something clarified, I will do my best to clarify for you.
Okay.
Okay? But we're not going to keep going around this maypole.
I'm sorry. I'm not a lawyer, so I'm sorry.
You don't have to be a lawyer. I'm doing my level best to explain it to you.
So
Okay?
am I not presumed innocent anymore?
Of course you are.
So
Jurisdiction innocence are two entirely different concepts.
Well, am I presumed innocent of all the elements of these charges
You are
still?
presumed innocent unless and until the state can prove you guilty beyond reasonable doubt, and you have the right to demand a trial to say, I'm going to put you to your proof.
So am I no longer innocent of all the elements of these
Of
charges?
course you're innocent.
Excuse me, what was
You
that?
remain innocent unless the state proves you guilty. That's what a trial is for.
So is that a yes, I am innocent of all the elements of these charges? I'm sorry, I'm not a lawyer. I'm just trying to get this clear for my records.
I've said this to you 3 times. Look, you seem like a pretty smart guy to me. Okay? Seem like maybe you have some behavioral health issues. I see here that you were a client of Kodak, or Coke, or some, one of them, Coke, Kodak, La Frontera, and the fact that you're coming from Judge McCall's Behavioral Health Board is further indication of that. And
Objection.
That's fine.
Is that an arbitrary opinion, or is that based on the record?
It's not an arbitrary opinion. It's based on what I've read in your file. But it's got nothing to do with the fact that you and I are here today with a garden variety, driving on a suspended driver's license ticket, and a couple of other little things.
That's not one of the charges, sir.
Failure to obey a police officer, civil no registration, civil no insurance. Okay? I'm the judge who sits the domestic violence bench for this entire county. Okay? This is traffic, son. Right? I realize it's important to you. And it's important to me. The rules are the same for everybody. You are presumed to be innocent unless the state can prove you guilty beyond reasonable doubt, and they've got to do it with their own evidence, and you've got a right to say, I'm going to put you to your proof, I want my trial. Any witness the state calls to the witness stand, you have the right to cross-examine. Cross-examination is questions that you direct to the witness concerning the witness's testimony or credibility. You have the right to introduce evidence and testimony. Son, look at me, please, when I speak to you. Come on, just stick with me here. I'm giving you your constitutional rights.
I'm trying to, sir. You're just saying a lot of things.
I'm sorry?
You're saying a lot of things, and it's hard to keep up. I'm not a
Okay, should
lawyer.
I go slower?
I still have the
Should I go
question.
slower, son?
I'd like a response to my clarification.
No. See, you're not in a position to do what you're doing right here. I'm advising you of your constitutional rights. And if you would like me to slow down, I am happy to.
You're talking
Right?
about trial, sir.
Sir. I'm a patient man. Right?
Okay.
And I am trying my level best to explain to you what the criminal process is. You're not going to question me. You don't get to question me.
No, sir. I'm not questioning. I'm
Yeah,
just
you are.
asking.
Yeah, you are. If you're asking me to slow down, I am more than happy to slow down.
Okay. Thank you.
Okay. In any criminal case, this one included, you have rights under the United States and Arizona constitutions. And I'm going to review those rights with you. You have the right to be presumed innocent unless the state can prove you guilty beyond reasonable doubt with its own evidence. And you have the right to say to the state, I'm going to put you to your proof. I want my day in court. I want to try it. I want to challenge your evidence. Any witness the state calls to the witness stand, you have the right to cross-examine. Cross-examination is questions that you direct to the witness concerning the witness's testimony or credibility. When the state concludes its presentation of evidence, you have the right to present evidence also. You have the right to call witnesses that you select, and you have the right to use my subpoena authority to compel witnesses to attend and testify. You have the right to testify in your own defense. You have the right to remain silent and not have your silence be taken as evidence of guilt. And if trial results in a conviction, you have the right to file a direct appeal to the conviction. Those are your rights, son. Do you understand your rights? Yes or no, please? Yes or no? Do you understand your constitutional rights?
I think so. I'm
Good.
just.
I'm glad to hear that. So
You're-
what I'm
you're-
going to do right now is I'm going to enter a plea of not guilty.
Objection.
No, please. You want me to plead you guilty? Come on, son. I'm entering a plea of not guilty to the criminal charge, not responsible.
Objection,
to the two
sir.
civils. Mr. Listen to me. You're interrupting me, and I don't react well to that.
Why are you
It's
entering a
rude.
plea on my behalf?
I'm sorry?
Why are you entering a plea on my behalf?
Because that's what you're here for, son. This is an arraignment. This is where I tell you what you're charged with, tell you your rights, and you enter a plea. You can enter a plea of guilty or not guilty. I'm assuming that you're entering a plea of not guilty.
Well,
Am I right or am I wrong?
I'd rather you not assume that. I'm still seeking clarification on the cause and
No,
nature of these
Mr.
proceedings.
So we're done here, son. We're done here. I've entered a plea of not guilty on your behalf to the criminal charge, not responsible to the civil charges, and I'm going to appoint a lawyer to represent you.
Objection.
You
I
don't
don't
want a lawyer? I'm going
No.
to give you a free lawyer.
No, sir, I don't want a lawyer, and I would move to have that plea withdrawn until I can get some clarification on the nature and cause of these proceedings.
You're going to come back to court. I'm going to read your motions. You're going to come back to court. What day of the week do you like better, Monday morning or Tuesday?
Afternoon.
Don't have an afternoon, I'm sorry. I can do Monday morning at 10 or Monday morning at 11, Tuesday morning at 10 or Tuesday morning at 11. Whichever is more convenient with you, you may select. I don't have an afternoon, son. My afternoons are trials.
And what is this for?
I'm sorry?
What is this for? What are you scheduling?
Yeah, it's called a case management conference. Was there been disclosure made?
Yes, Your Honor, disclosure
All
was
right.
made.
This is going to give me a chance to read your motion. Mr. Look at me, please. This is going to give me a chance to read your motion and come back and rule on your motions. And we'll decide at that time. So, pick
What
a
about
Monday or
the-
Tuesday. You decide Monday at 10 or Tuesday at 10. Or Monday at 11 or Tuesday at 11. Are you mom and dad? Can you help?
I don't think so anymore.
No? Okay. I'm doing my level best here.
I know you
Well,
are.
sir, I feel like you're rushing me to
No,
judgment.
see, I'm not rushing you, son, but I've repeated everything that I've said at least 3 times, in a couple instances 4. I realize that you may be having some trouble understanding what I'm saying. That for that reason, I offer to appoint you a free lawyer.
I understand what you're saying. I just still need some clarification on some other things that you
No,
haven't
this is what
clarified
we're
for
talking
me.
about. This is all we're talking about this morning.
And you're making me feel nervous here with these men with guns here standing next to me.
These men are not here because of you. They're here because of that guy in the back of the shirt, in the back of the courtroom in the blue shirt. These 2 gentlemen have nothing to do with you.
It's still making me feel nervous because
Well,
at
they
any
don't have
time,
anything to do with you, Mr. They're not here because of you. They're here because of Mr. Okay? Really, got nothing to do with you, son. Mr. Keep your voice down.
has the prosecution submitted any
No.
response to these motions?
No. Here's where we are. You're going to pick a Monday or a Tuesday. You decide.
Sir, I was hoping to resolve this
No,
today.
okay. I'm going to pick a date then. You're going to come back to court Monday, April 4, easy to remember, 4/4.
Well, I object.
April 4, yes, I know you object. Your objection is overruled. April 4,
On what grounds?
because I must set a date for you to return, son. Those are the grounds.
The
Under Rule
prosecution,
611 of the Rules of Criminal Procedure, I have authority to run my court the way I think is best in the most efficient fashion. What I am trying to do, Mr. Son, is protect your constitutional rights, son.
I would like
Please,
to, I would like
enough.
to,
Please, just enough. Please. April 4, Mom or Dad, do you like 10 or 11?
11.
11 it is. It's a mandatory appearance. If you don't show up, a warrant will issue. You need to be here.
More threats of
Where's your
violence.
copy? No more points of clarification.
No,
If you want a lawyer, I'm happy to appoint a lawyer for you, and you can raise all the points of clarification that you want with your lawyer. But I'm not your lawyer.
I'm not asking for legal advice. sir.
Good.
I'm just asking for clarification
No,
on the
we're
cause
done
and
with the
nature.
clarification. We're we're done with the clarification. This is Heidi. Heidi has a copy of your order. Would you please let me appoint a lawyer for you?
No.
So be it. We're done. Don't forget, it's a mandatory appearance sign.
And you'll have read the motions and the prosecution
Sir,
will
come on
have
up to
read them?
Heidi, please. Come to Heidi. Heidi will bring the order to you, whichever one you please.
Your Honor, would the court like written responses or would oral responses at the next hearing?
Oral responses at the next hearing will be perfectly all right.
Thank you.
I would like written responses since I'm
I
not a
don't want to start
lawyer.
up to you, it's up to me.
But I'm the defendant
It's
in this
my
case.
decision, I'm the judge.
I would request that I get a written response so I can defend.
I'm going to review your motions, and we'll take it up to hearings. You got your copy, we're done for today.
All right.
All done, sir.
This guy is fucking stupid!
Go home.